Hi, Bill Henshaw here again, unincourt@gmail.com. Another updated video and more good news as this COVID crap continues on. This not directly related to that, but some of you may have noticed that the Secretary of Education is just issuing new rules and regulations for how especially colleges handle claims of quote unquote sexual harassment. This has long been a real big problem, and these new rules, and I haven't seen an official uh, report on it yet, but are going to be much more aware of the rights of the accused here. This whole thing has been a debacle from day one, to say the least. So a step in the right direction. The problem is they're starting from the wrong place because the feds have no authority to even do this. That said, those of you out there that have had some problems, even if they're a while back, if, as I claim, these proceedings are legally null and void, nunc pro tunc ab initio, the official actors knew or should have known that to be the case. And you may have some serious redress or grievance coming your way for wrongs that have been done to you, but in effect converting what should be a criminal prosecution into an administrative proceeding. I would love to see the authority in the original Constitution to do anything like that, let alone do it from Washington, D.C. So that's it. For information on this, send me an email at unincourt@gmail.com. I'll get back to you and we'll see what we can do with it. In the meantime, tell your friends, subscribe, and get the word out here, because we have another area that's been created here for a lot of people to get back at the government that's very seriously mistreated them and abused their rights. It's just a matter of recognizing the truth. They're in the process of doing that right now at the Department of Education. So I'll have an update on this video when I get the official release so that I know what they're doing. Among other things, by the way, it's not clear, but if they're going to convert a criminal prosecution into an administrative proceeding, then not only do you have the right to effective assistance of counsel, the school district or college has to pay for it. That's the price they pay if they're attempting to do something the Constitution simply does not permit. So that's it. Okay, they were starting from the wrong place. What I should have mentioned was that all of this crap comes from Title IX of these education amendments in 1972. They, in turn, devolved from the Civil Rights Act of 1964. And that act of legislation owes its sorry-ass, egregiously evil existence to Section 5 of the non-existent 14th War Amendment. Anybody that attempts to make claims for any kind of judicial immunity from any of our actions that we intend to file, we probably won't even have to do it. But to try to make claims of that nature, they're done from the beginning, because they're official actors. They have a sworn duty to be bound by this Constitution and the laws enacted in pursuance thereof, Article 6, Section 2. And we're now going to have what looks like strict liability acts of treason to the Constitution they would have to deal with in front of an inflamed jury. Not a very pleasant prospect, and one that's likely to go a long way in having the bastards get their checkbooks out and getting it over with. So that said, like this video, tell your friends, get the word out, and send me an email at unincourt@gmail.com. Thank you.